Three politicians are challenging whether the intelligence service's bulk interception of electronic data is legal at a hearing later today. Green Party politicians Caroline Lucas and Baroness Jones, alongside former Respect MP George Galloway, say MPs' communications are being intercepted. They say this breaches a doctrine protecting MPs' communications. Our legal correspondent Clive Coleman sent us this from the Royal Courts of Justice.
This is an extraordinary hearing at the Investigatory Powers Tribunal. Now, it's the tribunal that hears complaints against the security services. It normally sits behind closed doors, but today it's sitting in public to hear a case brought by two current and one former parliamentarian. Now, they're mounting a legal challenge to the mass collection of communications data under something called the Tempora program. Now, this was a program that was revealed by the former US intelligence analyst Edward Snowden. And what the parliamentarians are saying is that if their data is swept up under that program, then that breaches something called the Wilson Doctrine. That goes back to the days of Harold Wilson, the former Labour Prime Minister, who in 1966 told Parliament that MPs' phones wouldn't be tapped. In 1997, the then Prime Minister Tony Blair expanded that to cover electronic communications. Now, one of the parliamentarians who's bringing this challenge is Baroness Jenny Jones of the Green Party. She's with me now. Tell me why it's so important to mount this challenge.
Well, it's obviously only a tiny part of the sort of state surveillance that we're seeing a lot of at the moment. But this is particularly about parliamentarians and their constituents. People write to MPs and to peers with sometimes very distressing stories, but also sometimes to blow the whistle on criminal acts by either state agencies or private organisations. And so to actually pin down that we can have privileged contact with those people, it's not for the parliamentarians, it's actually for the people who get in touch. They should be protected in their privacy so that they can feel free to say exactly what they want.
Now, you're not suggesting that MPs should never be subject to the collection of communications data, are you?
Absolutely not. I mean, if an MP or a peer is suspected of a crime, of course they should be under surveillance. But there's procedures already to do that. You can have a judge sign a warrant that allows whoever, the intelligence service or the police, to actually look at all their communications. So it's already in the law. But this is particularly about our relationship and our trust with our constituents.
And what is it that you do want? Do you want some kind of oversight, some kind of independent sign-off, so that if your emails are going to be collected, it has to go to, say, a judge to say, yes, it's okay in the case of Baroness Jones?
That's exactly right. We're not asking not to be looked at at all. We're just saying that there has to be a legal procedure. It's my suspicion that they're using the powers they have at the moment, or the ability they have at the moment, to actually look at us illegally. And for me, that's a big issue. I think that they have absolutely no right to intrude on the lives of private people who simply want to tell their parliamentarians something of interest.
And this proceedings today, it's unusual that we're having some of it in public, but some of it, of course, will be behind closed doors. Just explain why that is.
Well, of course, we don't know whether or not we've been under surveillance. We rather suspect we have been because, as you said, the Tempora program, and also, of course, I've been on the Met's database of domestic extremists for over a decade, and actually put me on that database of domestic extremists when I was an elected person and sitting on the Metropolitan Police Authority. What we would like to get out of today is the judges to say eventually that we will have that privileged communication, but we will not hear the evidence that the security services bring. That will be behind closed doors.
Well, there you have it. This is an important case. There is a real atmosphere around at the moment. We saw it with the report from the independent reviewer of terrorism legislation, David Anderson, who also was recommending judicial oversight in relation to the collection of data. People seem to want to know exactly what is going on and what the regime is for overseeing that and for authorising it.
Clive Coleman reporting.